Yes, be ready for the dictation. Start. It is averred that respondents number 1 and 2 have awarded the allocation of the work/project to respondent number 3 in complete violation and disregard to established practice. Stop. It is pointed out that the central government, in recognition of the importance of disaster management as a national priority, set up a high-powered committee HPC in August 1999. Stop. Subsequently, a national committee was also set up after the Gujarat earthquake for making recommendations on the preparation of disaster management plans and suggesting effective mitigation mechanisms. Stop. Thereafter, on 23/12/2005, the Government of India enacted the Disaster Management Act 2005. Stop. This act envisaged the creation of National Disaster Management Authority headed by Honorable Prime Minister and State Disaster Management Authorities, which was headed by the respective Chief Ministers, to spearhead and implement a holistic and integrated approach to the disaster management in India. Stop. The petitioner claims to be a global rescue foundation, having played a crucial role in the formation of the said guidelines, and valuable contributions have been made by the managing trustee. Stop. It was also submitted on 11/1/2019 that the petitioner, in collaboration with the National Museum, New Delhi, organized a national seminar on museum safety and disaster management for heritage at the National Museum, being the first seminar of its kind, which was attended by over 200 participants, with a representative from NDMA, NDRF, CISF, Ministry of Culture, Geohazard Society, NIDM, and other agencies, and representatives from various museums across the nation. Stop. A certificate was also issued to the petitioner. Stop. Learned Counsel for the petitioner submits that on 13/3/2019 a communication was addressed to respondent number 2, highlighting that in spite of existence of express guidelines for museum safety that have been in place since 2017, respondent number 2 was yet to have its own disaster management plan, which had been mandated not only by the NDMA but has also been mandated under the Disaster Management Act 2005. Stop. The petitioner offered to provide holistic A to Z services for all the safety concerns, as well as the storage and maintenance of the collections of the respondent/museum in a scientific manner, considering all the factors such as fire safety, earthquake safety, flood safety, chemical disaster safety, mob attacks, and such other natural and man-made disasters and calamities. Stop. The petitioner was hoping that the proposal so made would be accepted. Stop. In response to the communication so made, respondent number 2, Museum, through its Additional Director General, replied on 22/3/2019, citing the broad scope of work involved, and the petitioner was requested to go through the same and submit an offer for the preparation of the disaster management plan for the National Museum. Stop. A broad map was submitted by the petitioner on 23/3/2019. Stop. Several suggestions regarding various aspects which ought to be added by the respondent/museum were also made. Stop. It was suggested that the entire work should be carried out under a nodal officer deputed by the NDMA in association with the representative of the National Museum. Stop. Learned Counsel further submits that thereafter there was complete silence from the side of the respondent despite the fact that the petitioner made attempts to seek further information in regard to technical criteria for selection of an agency. Stop. The petitioner was called upon to submit a financial bid by 30 for 2019. Stop. The financial bid was submitted. Stop. It is submitted that the petitioner again sought information with regard to the technical criteria that was adopted by respondent number 2 for selection of an agency for preparation of a disaster management plan. Stop. However, the petitioner was informed on 11/5/2019 that respondent number 2 had already awarded the work for preparation of its disaster management plan to another agency. Stop. It is the case of the petitioner that in appointing respondent number 3, the respondent number 2 has acted in an opaque and malified manner, showing disregard to the due process, and has appointed an agency which involved public expenditure without any advertisement, any tender, or any publication seeking any expression of interest, and without determining the criteria for selection. Stop. It is contended that the procedure adopted is unknown to law. Stop. It is further alleged that the entire process was carried out in a hushed manner in complete derogation of the established norms with the sole objective to benefit respondent number 3. Stop. It is further contended that the core area of expertise of respondent number 3 is architectural heritage and conservation, which has nothing to do with the preparation of a disaster management plan. Stop. It is contended that since the petitioner was unable to seek details from the respondents, he was left with no option but to take recourse under the RTI Act. Stop. An application was sought with regard to the technical criteria adopted by respondent number 2. Stop. Learned Counsel for the petitioner also submits that as per Office Memorandum dated 30/11/2011 issued by Ministry of Finance Department of Expenditure, it is now mandatory for all ministries/departments of the central government, their attached and subordinate offices, CPSCs and autonomous/statutory bodies to publish their tender inquiries online on the Central Public